At exactly 3:17 p.m. Eastern Time on January 10, 2026, an event occurred that has no precedent in the 249-year history of the United States. A sitting federal judge formally referred criminal conduct by a former president directly to Congress and explicitly called for immediate impeachment proceedings. This was not a leak. It was not a rumor. It was not an anonymous tip or partisan speculation. It was a signed, filed, public legal document submitted through official judicial channels. Judge Tanya Chutkin, acting in her capacity as a federal judge, concluded that the evidence before her left no alternative. Congress, in her judgment, could no longer delay action without endangering the administration of justice itself. This moment cannot be overstated. A lifetime appointed federal judge examined a record consisting of 14 documented violations of court orders, repeated witness intimidation, coordinated obstruction of justice, and sustained contempt for judicial authority. After months of escalating warnings, sanctions, and hearings, she reached a conclusion no judge in American history has ever formally reached: that congressional intervention through impeachment was not merely appropriate, but necessary and urgent. This conclusion was not expressed rhetorically. It was expressed legally in writing, backed by evidence, and transmitted through constitutional channels. The referral came in the form of a 47-page legal filing now available to the public. It is not a summary, it is not a memo, it is a comprehensive evidentiary record, and within approximately 72 hours of that filing, the House of Representatives is scheduled to vote on whether Donald J. Trump becomes the first individual in American history to be impeached 3 times. This is not conjecture. This is the procedural consequence of actions already taken. For months, this trajectory has been visible to anyone willing to look past daily outrage cycles and focus on institutional behavior. Warnings were issued, boundaries were tested, court orders were ignored. The judiciary exercised restraint, the defendant escalated. This was not sudden, it was cumulative, and on January 10th, the machinery of accountability moved from tolerance to enforcement. Judge Tanya Chutkin presides over one of the federal criminal cases involving Donald Trump. Over the course of this case, she has confronted a situation no federal judge has ever faced at this scale. A defendant with extraordinary resources and political influence who repeatedly refused to comply with court orders. Gag orders were violated, witnesses were contacted despite explicit prohibitions, public statements targeted prosecutors, judges, and potential jurors. Social media was used as a tool of intimidation and influence. These were not isolated incidents, they formed a documented pattern. 14 separate violations occurred within a 3-month span. Each violation was addressed by the court, warnings were issued, contempt citations were filed. Fines were imposed, the defendant was directly admonished in open court. Transcripts show explicit explanations of what conduct was prohibited and why. Despite this, the behavior continued, not sporadically, but systematically. At a certain point, judicial restraint ceases to function as restraint and begins to function as permission. Judge Chutkin recognized that threshold had been crossed. The authority of the court depends not on symbolism, but on enforcement. When court orders can be violated repeatedly without meaningful consequence, the credibility of the judiciary erodes not only in one case, but across the entire legal system. This was no longer a dispute between a judge and a defendant. It had become an institutional crisis. The criminal referral filed by Judge Chutkin reflects that understanding. In the document, she states that the defendant's conduct constitutes a clear and present danger to the administration of justice, and that it demands immediate congressional intervention. These words matter. Clear and present danger is not casual language. It is a legal determination with a long and serious history in American jurisprudence. It signals imminent harm to institutional integrity. The referral did not rely on inference or speculation. It included a comprehensive evidentiary record, 14 separate gag order violations, each time-stamped, archived, and preserved. Transcripts from 7 contempt hearings in which the defendant was warned directly by the court. Phone records indicating coordination with co-defendants in violation of no-contact orders. Social media posts targeting prosecutors, judges, and individuals within the jury pool. Internal communications from the defendant's own legal team acknowledging violations. Sworn declarations from former federal judges characterizing the conduct as unprecedented. And most significantly, recorded audio conversations in which the defendant discussed plans to defy court orders with close advisors, evidence that speaks directly to intent. Intent is the dividing line between negligence and criminality. The presence of intent transforms misconduct into obstruction. It elevates violations from procedural issues to constitutional threats. This is why the referral carries such weight. It does not merely describe bad behavior. It documents a deliberate strategy to undermine judicial authority. What makes this moment historically singular is not only the conduct itself, but the response to it. Never before has a sitting federal judge formally initiated impeachment proceedings against a president or former president. Not during Watergate, not during the Clinton impeachment, not during the Saturday Night Massacre. In those cases, courts adjudicated disputes, but they did not directly petition Congress to exercise its impeachment power. Judge Chutkin crossed that line because, in her judgment, the circumstances left no alternative. To understand why this step was taken, it is necessary to understand the limits of judicial power. Federal judges possess tools to enforce compliance, warnings, fines, contempt sanctions, and in extreme cases, detention. But those tools depend on proportionality and legitimacy. When a defendant is wealthy enough to absorb fines without consequence, influential enough to render detention politically explosive, and defiant enough to treat warnings as performance, the traditional enforcement ladder breaks down. Judge Chutkin faced a defendant who treated court orders as suggestions and consequences as talking points. Each unpunished violation weakened the authority of the court not only in this case, but across the judiciary. At some point, the question becomes not whether the defendant respects the law, but whether the law can enforce itself. That is the moment at which constitutional mechanisms beyond the judiciary must engage. The referral reframes the entire political narrative. For years, the defense has been that investigations into Trump are politically motivated, driven by partisan prosecutors or ideological judges. That argument collapses when the action originates not from a prosecutor or legislator, but from a federal judge acting under oath, relying on documented evidence, and operating within established procedure. This was not a press conference. It was not a leak. It was a filing. Congress was not unprepared. Articles of impeachment had been drafted months earlier and held in committee. 8 charges were outlined, including obstruction of justice, witness tampering, contempt of court, violation of judicial orders, abuse of power, conduct unbecoming a public official, threat to the constitutional order, and incitement. Prior to the referral, those articles had approximately 87 co-sponsors, all Democrats, insufficient for passage. Within hours of the referral, that number surged to 231, a majority of the House of Representatives. Enough to impeach immediately. The most significant detail is not the raw number, but its composition. These were not only progressive Democrats. They included moderate Republicans from competitive districts who had previously defended Trump during earlier impeachments. Representative Mike Lawler of New York, a Republican from a district carried by President Biden, publicly stated that his oath was to the Constitution, not to any individual. Representative Don Bacon of Nebraska echoed that sentiment. These were not ideological opponents. They were political survivors responding to a shift in institutional legitimacy. House leadership invoked Rule 99, Section 2, a fast-track procedure requiring a full House vote within 72 hours. That procedural move eliminated delay. By Monday, January 13th, the House will vote. With the current co-sponsor count, impeachment is no longer a question of possibility, but of margin. As this unfolded, the defendants' public response intensified rather than moderated. Social media posts escalated in frequency and severity. Claims of rigged courts and political persecution continued, but one statement triggered immediate alarm across Washington, a post calling for patriots to converge on Washington and invoking the Second Amendment as justification crossed a critical threshold. Such language is not abstract. It exists within the context of January 6th. Law enforcement agencies do not treat it as rhetoric. They treat it as a risk vector. Every statement now becomes evidentiary. Every escalation strengthens the legal case against the Speaker. The response was immediate. National Guard units were deployed. Federal buildings were reinforced, security perimeters expanded, demonstrations formed, counter-demonstrations followed. Washington entered a posture not because of an election or foreign threat, but because of a domestic constitutional crisis involving a former president. While much coverage focuses on the impeachment vote itself, the more consequential development lies beneath the surface. The evidence transmitted to Congress was also forwarded to the Department of Justice. That means the political process and the criminal process are now running in parallel. Witness tampering and obstruction of justice carry significant criminal exposure. Grand juries are active. Additional indictments are plausible. This convergence of accountability mechanisms is rare, but not unconstitutional. The framers anticipated moments when multiple branches would act simultaneously. What they did not anticipate was the scale or intensity of such convergence in the modern media environment. Quiet discussions regarding the 25th Amendment have also been reported. The amendment allows for removal when a president is unable to discharge the duties of office. It requires the vice president and a majority of the cabinet. It can move rapidly. Whether it will be invoked is unknown, but the fact that it is being discussed is itself historically significant. The Republican Party is fracturing in real time. Loyalists are doubling down while pragmatists are defecting. Internal threats are rising. Electoral calculations are shifting with the 2026 midterms approaching. Once public defections begin, momentum accelerates. Political coalitions do not collapse gradually. They collapse suddenly. International observers are watching closely. Allies are alarmed. Adversaries are assessing instability. Domestic constitutional crises have global consequences. Markets react. Confidence erodes, uncertainty spreads. For ordinary Americans, the implications are tangible. Economic uncertainty increases. Trust in institutions is strained. Safety concerns rise, particularly in Washington. Families adjust daily routines. Federal employees alter commutes. The crisis is not abstract. It is lived. No matter what happens Monday, the political landscape has changed permanently. If impeachment passes and conviction follows, Trump is barred from future office. If impeachment passes and acquittal follows, the evidence becomes permanent record and legal exposure remains. If criminal indictments proceed, the process continues regardless of congressional outcomes. These scenarios are not mutually exclusive. Multiple paths may unfold simultaneously. That is the defining feature of this moment, converging accountability. Three facts anchor everything else. A federal judge has formally referred criminal conduct to Congress for the first time in American history. The House will vote on impeachment within days, with sufficient support already in place. And this moment extends beyond impeachment into a broader reckoning over the rule of law, institutional authority, and constitutional restraint. This is not a moment for passive consumption. It is a moment that will define how power is constrained in the modern era. The next 72 hours will echo for generations.